Good evening, and thank you so much for joining us after a long holiday weekend. We realize this webinar was announced without a whole lot of notice, but the issues we're going to dive into tonight are extremely timely, and we have a very rare window to hear from two of the most important voices in the space now. We are incredibly honored and grateful to have with us tonight Nadine Strawson and Dr. Jay Bhattacharya. I
Nice to
know
be.
many of you, good to have you. I know many of you are familiar with Nadine already. She's on FAIR's Board of Advisors. She's a New York Law School professor emerita and and senior fellow at FIRE. She was national president of the American Civil Liberties Union from 1991 to 2008. She's an internationally acclaimed free speech scholar and advocate who regularly addresses diverse audiences and provides media commentary around the world. She's always traveling and speaking. Please trust me when I tell you that. And Jay Bhattacharya, new to the FAIR family, he's a professor of medicine at Stanford University. He's a research associate at the National Bureau of Economics Research and a senior fellow at the Stanford Institute for Economic Policy Research. He directs the Stanford Center on the Demography of Health and Aging. That's very important, you'll see in this conversation. Dr. Bhattacharya's research focuses on the economics of healthcare around the world with a particular emphasis on the health and well-being of vulnerable populations. Notably, for the purposes of this webinar, Jay is one of the plaintiffs in the recent landmark First Amendment case that was recently dismissed by the Supreme Court just last month, Murthy v. Missouri. Now, I wanted to bring these two luminaries together for this discussion as part of FAIR in Medicine's new effort to broaden our scope. For many of us, the COVID pandemic was a wake-up call. It exposed institutional failures on multiple levels, but one of the greatest failures occurred in medicine and public health. And in retrospect, those failures occurred primarily because of a lack of open discourse and debate in the medical and scientific community. FAIR is committed to addressing head-on this lack of open discourse and debate and its undeniable effect on patient care, because we believe that educating our community and the public around these issues is critical to quality patient care and the ethical practice of medicine. So we are building a network of independent-minded doctors who are willing to challenge established narratives and speak openly and honestly about issues that affect our health. This, of course, can only be enabled by robust free speech. However, as I'm sure you're all aware, our federal government has recently taken very aggressive steps to curtail the First Amendment in its effort to stop the spread of misinformation. Tonight's webinar will be the first of many that FAIR will host on informed consent, and we decided to lead with this landmark case that the Supreme Court ruled on last month, Murthy, Missouri. Dr. Bhattacharya was one of three plaintiffs who brought this groundbreaking lawsuit. And as a reminder, we'll be saving some time for Q&A towards the end of this event, so just pop your questions into the chat as we go. Okay, so with that said, Jay, let's start off. Can you give us some background on the circumstances that led you and your colleagues to file this lawsuit?
Sure. So first, it's actually the Missouri and Louisiana Attorney General's offices were the lead plaintiffs in the lawsuit. I never imagined I'd be part of a lawsuit. Actually, never really until the pandemic been involved with the legal system at all. I wrote an alternative to the management of the pandemic, a one-page document called the Great Barrington Declaration, in October of 2020. With Sunetra Gupta of Oxford University and then Martin Kulldorff of Harvard University. It got a lot of attention, like 1 million people, almost 1 million people signed it, tens of thousands of doctors signed it. It argued that we should do focused protection of vulnerable older people and lift lockdowns, which doesn't sound all that controversial now, but in October 2020, it was tremendously controversial. It led to just all this attention, like some positive, but a lot of like negative attention as well, hit pieces, death threats. It was kind of a crazy time. Online, it was interesting because there was like if you looked online, you could find it for the first few days very, very easily on Google and so on. But within a couple of days, you couldn't find it on Google. It was like down to the bottom. The Facebook page for it was like taken down. There was on Twitter, people were like getting suppressed for sharing it. I wasn't on Twitter at that point. And I was just a regular citizen. I didn't know what was happening. It just was really strange to me that the tech companies would independently all decide together that this was not going to be allowed to be shared. I did join Twitter in August of 2021. I got a lot of followers very quickly, but it was really clear I was preaching to the choir. I post something and a whole bunch of my followers would see it, which made me feel good. The dopamine hit was right there. But I went on Twitter because I wanted to tell other people that didn't agree with me or hadn't heard of the Great Barrington Declaration, and I didn't feel like I was reaching them. When Elon Musk bought Twitter, it turned out that I'd been placed on a blacklist the first day I joined Twitter. And so in 2022, when the Missouri and Louisiana Attorney General's office contacted me asking if I'd be willing to be a plaintiff in the case, where the allegation was that the government itself was asking or coercing or pushing these tech companies to suppress my speech, I jumped at the chance because I wanted to peek behind the curtain and see. And I, as a regular citizen, I mean, I'm not very litigious, you guys. So I just put that out there. But I figured I'd have a chance to see, and so I agreed to go on the case. And in fact, the discovery on the case was really eye-opening. It led to all kinds of information about the tactics used by the government to suppress speech like mine on the internet. There was this wasn't directly part of the case, but earlier there'd been a FOIA that revealed that that the head of the National Institute of Health, a man named Francis Collins, had 4 days after he wrote that declaration, called for a devastating takedown of the premise of the declaration, labeled me, Martin Kulldorff of Harvard, and Senator Gupta of Oxford, fringe epidemiologists. I mean, the government was very, very directly involved in suppressing this kind of speech, which is what the discovery in the Missouri versus Biden case showed. We'll talk maybe more about the ruling in the Supreme Court, which was disappointing. But I'd love to hear your guys' thoughts.
Nadine, so the court's recent dismissal of the case Jay's referring to for lack of standing has been met with criticism. The criticism has been that the court simply wanted to punt this issue and not really address it. And it's one of the biggest issues of our time. So very disappointing. Do you think, is it a fair assessment that there was, in fact, a lack of standing here? Or do you think the decision might possibly have been affected by concern about misinformation in the upcoming election?
Monica, I'm going to assume that not every member of the audience knows what standing is. So please forgive me if I start by a basic definition. Standing is a court-created doctrine. It is not something that appears in the Constitution itself. Judges on the Supreme Court have created the standing doctrine as a self-imposed limit on the power of federal courts to rule on cases. The textual basis in the Constitution for the standing doctrine is rather slender. It is the two words in the article of the Constitution, Article 3, that creates the federal courts and empowers them to rule on cases. Specifically, one of the two crucial words is cases, and another one is controversies. And the Supreme Court has said, well, it's not really a case or a controversy unless one of the plaintiffs has standing throughout the proceedings. And standing consists of three elements. Number one, that there is a particularized concrete injury to that party. Number two, that the injury is traceable to the complaint of conduct. And number three, that the remedy that is sought would redress the concrete harm. So all of these are created by courts, and I have to say a number of scholars have argued that the whole standing doctrine is an illegitimate, unjustified, undue restraint on the power of the federal courts. Beyond that, even those who support the standing limit on federal courts' power in theory, say that it is so vague. The standards are so manipulable, to use a kinder word, so flexible, that it becomes an easy way for the court to do exactly what you suggested it might have done in this case, and that is to have a pretextual reason for avoiding a ruling on the merits of the case, regardless of whether that is something that did or did not happen here, Monica. We don't know what motivates a particular Supreme Court justice to rule a particular way. There is no doubt that the vagueness of the standing doctrine gives an opportunity for justices to do that. And one of the complaints by the dissent in this case, authored by Justice Alito, was that the enforcement of those standing criteria in this case was much stricter than it had been in past cases. So, perhaps a justice really was manipulating the doctrine. But putting that aside, I think, let me say why I think it is so important for the court to actually rule on cases that raise such important constitutional issues, and that is because of the rule of law. What is First Amendment freedom of speech in reality if a violation of it goes unredressed in the courts because of this judge-created doctrine? As the lower court very dramatically, but I think not over dramatically stated, that this is probably one of the most profound and largest violations of free speech that we have seen in our history. And I want to make one other point to add to Jay's excellent explication. And thank you, Jay, for, no pun intended, standing up for your free speech rights and therefore for the free speech rights of everybody. And I really want to underscore everybody. I think that the information and the opinions and the analysis that you and your colleagues put out are incredibly important, whether people are ultimately, agree with you or disagree. This is part of not only free speech, but of the scientific method, right? That all analysis, all hypotheses, all evidence should be put out there and debated and discussed on the merits, not suppressed. And that's the way that we find scientific truth as well as truth in general. But even putting that aside, I have to tell people that everybody has a stake in the issues here. If you happen to be a Biden supporter and supporter of the pressure that was put on what they perceived as being disinformation in this case, that means that you should still not accept the government being able to coerce or unduly pressure private sector actors to suppress speech that indisputably is constitutionally protected. Nobody claims that the government could have directly suppressed this information, right? So to quote my colleague, Jonathan Turley, this is censorship by proxy. The government is doing indirectly what it is not allowed to do directly by pressuring the social media companies. That is something that is so dangerous that the most ardent Biden supporter should oppose it, because if in the hypothetical situation that Biden might not be reelected, that Donald Trump might be our next president, we can anticipate that the Trump administration or whoever else is in power in the future is going to use that same pressure to suppress what it considers to be disinformation, or in Trump's preferred term, fake news.
And it's interesting that you mentioned about the court-created doctrine of standing, Nadim, because I couldn't help but think, well, if someone like Dr. Bhattacharya doesn't have standing in a situation like this, who would have standing? Does the court give us any clue who would be a more appropriate plaintiff? I don't think they do.
Well, one of the ironies, Monica, is that in many cases, nobody has standing. One of the aspects of this doctrine is what the court has called the generalized grievance. A generalized grievance means that a government policy is adversely affecting the population in general, the public in general. And that means that nobody has standing because no particular individual has a particularized concrete grievance, which seems exactly the opposite of what the impact should be, right? So the more people who are more broadly harmed by a general government policy, the less likely you are to get a remedy in court. You know, one of the very first important constitutional law decisions, as every constitutional law student and many other members of the public know, was Marbury versus Madison by Chief Justice John Marshall, in which he basically, explicated the important power of judicial review to strike down as unconstitutional laws or measures that were taken by the executive branch. And he basically says that if there, for every right and every violation of every right, there must be a remedy, that is the essence of the rule of law and of civil liberty. So by subsequent courts creating this escape clause so that courts do not have to provide a remedy for a constitutional violation, for all practical purposes, that means the right itself is being eviscerated.
Yeah, that's totally hollows it. Yeah.
Can I jump in on that?
Oh, yes, absolutely.
Yeah, because I think it's such an important point. I mean, it wasn't so much that my particular First Amendment rights were violated, although I do think they were. It's that basically every American's First Amendment right was violated by this sort of policy that was, and I think it was even before the Biden administration, this kind of action was happening. So I don't think it's just unique to Biden, but like the case was on the Biden against the Biden administration. The key thing there is that if they require standing, so like this traceability, forgive me, Nadine, if I get this wrong because I'm not a lawyer, but like this traceability standard, you have to essentially show a chain of email from some government actor to a social media company that says censor J. And then combine that with an or else. Or else we're going to do something to you, right? So you have to show this thing. Let's say you actually could find somebody like that. It's possible in principle to find something like that. What the substantive impact is that the government then can, as long as they don't name an individual, they can just name an idea. The Great Barrington Declaration, the idea that opening schools is a good thing for children, actually, or whatever it is, and they can suppress that idea, and there's no recourse within the courts to tell the executive branch that they're not allowed to do that they're not allowed to suppress an idea. I don't know what's left of the First Amendment if the government then is allowed to suppress ideas in this way, as a general matter, essentially require this kind of individual standing in order to get redress.
And Jay, I could not agree with you more on two really important points you made. Number one, that these kinds of policies had, in fact, speaking again, another pun, can be traced back to the prior Trump administration. At least some of the suppressive policies began then. But because the case is focused on Biden, I think a lot of supporters of Biden were so concerned about, supporting his administration that they lost sight of that larger factual context and the overarching principles that go way beyond any particular administration and any particular speaker. And by the way, the First Amendment protects not only the right of you and others to convey information and ideas online, but the right of all the rest of us to receive ideas and information. The Supreme Court unanimously has so held. So literally everybody who was deprived of reading what you put out there was a victim of a First Amendment violation. Now, in fairness, I really do want to say the countervailing principle here, we're saying that government may not coerce or unduly pressure a private sector entity, including a social media company, to engage in suppression that the government itself could not directly do. But we all recognize that the government does have, and government officials have, free speech rights of their own, and government has justifiable power to seek to persuade private sector entities not to air certain communications that are, in the government's view, adverse to important public interests. So if what was going on here was simply discussion, communication, encouragement, persuasion, advocacy, that is constitutionally permissible. But the factual record here, I thought, made a very strong case that many of these communications crossed the line from permissible persuasion to impermissible coercion.
I mean, there were direct threats. I mean, and some of the emails from the government to the social media companies, because the social media companies rely on the government regulation. There's, I guess, the Communications Decency Act, the Section 230 of it protects the social media companies from being sued for, I don't know, libel or whatnot. If they publish something that I write that's libelous, the social media companies are not liable for that because of Section 230. And essentially, the government was threatening the social media companies, saying, look, if you don't censor these ideas, then we're going to go after you on this regulatory reform. This wasn't part of the case, but there was a congressional investigation into this, and what they found was that the social media companies require representation in international settings, right? So there's a European Digital Communication Act.
Mm-hmm.
Right. Sorry, I don't know the name of it, but essentially the social media companies are liable for tremendous amounts of damage imposed by foreign governments, and the Biden administration, any American government, should stand up for American companies in these negotiations. And the implied threat was if they didn't comply with the censorship orders, they wouldn't get the representation that they sort of deserve. So in this case, it was a direct coercion. The other thing that was striking to me is that a lot of what the government ended up saying about COVID policy and COVID science turned out not to be right. And it was. I mean, I know that the First Amendment even protects incorrect speech, but in this case, the consequences could not have been greater, right? So if all these children were out of school for a year and a half or longer, especially minority kids preferentially out of school, the pressure to not say that opening schools is a good idea was tremendous. Or the vaccine mandates, right? They're premised on the idea that you couldn't get or spread COVID if you had the vaccine. The evidence on that was actually really, really poor. But if you were to say that online, you get suppressed. It had substantive impact on the confidence that people currently have on public health. It had real substantive impact, and if there had been free speech, the government could have had its say, but then would have been criticized. That's the normal give and take of democratic societies, the normal give and take of science. I personally don't want to restrict the government's speech on these matters. They're often right. The issue is that they should not have the power to suppress silently behind the scenes where people don't even know about it, criticism of their positions. It's just a very dangerous thing for government to go uncriticized or uncriticizable.
That's a problem in general with the whole concept of disinformation, which has become such a popular mantra now. I just read about yet another book that's on the New York Times bestseller list, advocating that the social media companies voluntarily restrict disinformation. And even that I see as problematic. They're not constrained by the First Amendment. But if, as you say, Jay, what we are seeking is, first of all, democratic discourse on major public policy issues, but also scientific truth or truth in every realm, the only sure way to pursue that successfully is through open dialogue and discourse. Of course, it is not guaranteed to lead to the truth. But I think history, and including very recent history, as you outline, demonstrably proves that the opposite is true, that censorship is guaranteed to deprive us of arriving at the truth.
Well, Nadine, you guys have raised a point that may be a little confusing to our readers, which is, or our listeners, which is the First Amendment generally protects speech from government punishment or censorship, even if the speech is false or dishonest. What the First Amendment does not protect is false statements or false written statements about another individual, and then we get into defamation and libel. But just information in general, it's not, we have no obligation to speak, quote unquote, the truth about general principles. We can say that gravity doesn't exist, and the government shouldn't have a problem with that. So with that in mind, I guess the question is, what really is the basis for the government's defense here? Their argument is that, if I'm understanding this, is that there's a necessity to censor this information through social media companies because it's not accurate, because it's misinformation. But how does that square with the protection we get under the First Amendment to speak falsely? If that makes sense.
It does make sense, Monica, and I'd love to hear what Jay has to say on this. But speaking specifically about the legal concepts here, which you correctly raised, the government may, and here I think the government's major defense in this case, aside from the technical standing argument, but on the merits, was we are not crossing the line to coercion. What we are simply doing is trying to persuade these companies not to air material that we believe is untrue and that we believe is going to lead to adverse public health consequences or adverse consequences for particular individuals' health and safety. The government itself recognized that this was constitutionally protected. If it was not, the government itself could have, directly outlawed that expression, precisely because it recognized that even if, assuming for the sake of argument, these statements really were false and really were dangerous, that would not come within one of the very few specific categories of intentionally false speech that directly cause tangible harm that are subject to restriction. A major example, which you mentioned, Monica, is defamation, where there is an intentional statement, misrepresentation of fact that directly and demonstrably harms somebody's reputation, causing financial damage. Another example is fraud, where you intentionally state something false, intending somebody to rely on it to their detriment. They do rely on it to their demonstrable detriment, usually financial. And the third major example is perjury, intentional misrepresentation in a court of law that undermines due process of law and the rule of law. But beyond that, the fact that disinformation or lies or misleading statements might lead to some adverse consequences or more diffuse adverse consequences is no justification for censoring it. And in particular, the Supreme Court has said, under the First Amendment, there is no such thing as a false idea. What we're talking about here really are not statements of verifiable or falsifiable concrete objective facts. What we're really talking about are matters of interpretation, analysis, opinion. And so there can't be any falsehood. But what the government was arguing was, well, but that's exactly why we're not outlawing it. We're simply trying to discourage it.
Discouraging.
Can I make a follow-up public health point on this? If you're a public health agency like the CDC or something, and there was a hypothetical that Justice Jackson had in the oral arguments for the case, which was kind of interesting. She said, well, imagine there's a social media craze of kids jumping out of windows. one on higher and higher floors, right? Daring each other to jump out of windows. The government, as a public health matter, should have the capacity to tell social media companies, well, you probably don't want to share this content because kids are going to jump out of windows and be harmed, right? That's the hypothetical. The issue is actually fundamentally, leaving aside the legal matters, fundamentally from a public health perspective, a question of trust. Right. So if you have a trustworthy public health agency where people look to the public health agency for advice that matters for their own lives, and you know that when you listen to them, your lives are better, there's really no need for suppression, right? Because then what can happen then is, like, this happens in the Swedish public health agency has like almost universal trust. They put out some statement about some advice, and most people just listen to them. Even corporations will listen to them because they're trustworthy. If you have a censorship regime where the statements of a public health agency are backed up by this censorship, it ultimately undermines the trust on which the public health agency really makes its living. And that's, I think, what's happened here, right? That I've never in my professional career seen the trust in the American public establishment at so low a level. It's because they got so much wrong and then suppressed the countervailing force within the scientific community that would have corrected them. And so many people's lives then were disrupted by vaccine mandates, by school closures, by business closures, and so on. And so as a result, they can't engage in the kind of speech that they normally would be effective because they've sapped away all of the trust they normally would have. Free speech is the way that you resolve that problem. You resolve it because then when the government's wrong, when the whole health agency is wrong, they're corrected, they change their minds, and they become trustworthy. You become trustworthy not by being right all the time. That's humanly impossible. You become trustworthy by admitting error when you make it, forthrightly trying to correct yourself. And free speech is central to that process.
That's such an important point, Jay, because you're showing that not only was there a specific set of harms in terms of policies that were misguided and dangerous to public health, but even beyond this particular crisis, the whole public health establishment is undermined, which may do incalculable damage in the future. On the importance of free-flowing information, including what some people might consider to be disinformation, in a public health crisis or any other crisis, there's a very strong argument that it's especially important to allow all perspectives and all ideas out because it is such a fast-breaking situation. And that is exactly what a federal judge ruled in Puerto Rico. The ACLU brought a lawsuit to challenge an anti-disinformation law that was passed shortly after the pandemic began, where the government had the power to suppress what it considered to be dangerous information that would undermine public health. And we brought suit on behalf of a couple of investigative journalists who said, look, they were very well respected, especially the most conscientious journalists are going to want to put out as much information as they can as quickly as possible so that the public and other experts can debate it. And we're going to have to either face these, criminal sentences or civil penalties, or else we're going to engage in self-censorship. And the judge was persuaded. The judge said, for the sake of public health, as well as freedom of speech in a public health crisis, it is especially important that we reduce every kind of suppression, certainly direct suppression, but also the indirect suppression by proxy that we saw in these cases. I'd like to put out there one other important legal point, which is that at almost the same time that the Supreme Court denied, relief in your case on the basis of standing, it did unanimously strike down very similar, you know what I'm going to say, actions by other government officials in my home state of New York in a case involving the National Rifle Association, the NRA, where there was more explicit government threats against companies, banks, and insurance companies, that if they did business with the NRA, because this was under the Cuomo administration, because the NRA's policies were disfavored, the NRA's speech was disfavored by that administration, it would reward these companies by going lightly on them from a regulatory perspective if they voluntarily ceased doing business with the NRA. And the justices there had no problem unanimously finding that those communications did cross the line and therefore violated the First Amendment. The conclusion, as Justice Alito points out in his dissent in your case, when you juxtapose the two, is that there's now a roadmap for government officials. I think you already indicated this, Jay. So we're going to find more subtle and nuanced, veiled ways of communicating exactly the same message. And that's, as we lawyers would say, a distinction without a difference. You can accomplish exactly the same result with exactly the same adverse impact on everybody's free speech and access to information.
I have to say, I was so disheartened by the pairing of those two. And then there was another ruling in this net choice case, which essentially said that I think, if I, again, correct me, please, if I have a blind spot for.
Oh, you've become a self-educated lawyer, no doubt about it. I'm sure you know more about litigation than most law professors.
It's been I mean, I'm just a fringe epidemiologist, Nadine. Nothing. But yeah, it's the case that basically said that the social media companies themselves have a right to changing how they do their terms of service and all that, which is great. So essentially, what we have then is, if you pair all these cases together, is you have a corporatized free speech. Corporations can have free speech. The government can have free speech. The government can't suppress a particular individual through pressure, but it can censor ideas all it likes because those not traceable. That's the version of free speech we now have in the internet age, and it just strikes me as like I mean, maybe I'm being hyperbolic, but that isn't the kind of America I grew up in, where free speech was a part of a civic religion. I mean, the ACLU, Nadine, as you know, defended the KKK's right to speech. Why? Because it was so. If you defend their right to speech, then literally everybody's right to speech is defended, right? That's what made America the sort of the shining kind of example for the world on speech. What we have now is a very constricted version of that, authorized by the Supreme Court, and I'm wondering what the remedy is. I mean, I'm thinking maybe there needs to be laws, like the Congress should pass a law, and the president sign it. I mean, there are other branches of government, but I please talk me down off the ledge. I'm starting to give up hope on the.
As a civil libertarian, I am very skeptical about a law that is likely to do more harm to free speech than good. But what we need to do, Jay, is you're talking about the power and the First Amendment rights of social media companies to voluntarily, let's assume that they truly voluntarily are restricting certain ideas and certain speakers. I do defend that. To me, that is a less undesirable situation than having the government do what the governments of Texas and Florida did in the net choice cases, which was to restrict the discretion, the editorial discretion of the social media companies to engage in content moderation. That to me is an even worse. The solution.
No, I agree with you about that.
Yeah.
Entirely agree with you about that.
So,
yeah.
but I totally agree with you that the question is, so what do we do? And what advocates of digital free speech have been urging for a very long time, and here I'm channeling not only the ACLU, but the Electronic Frontier Foundation, the EFF, based in your neck of the woods, which does tremendous work in this area, have been advocating a couple of approaches that would facilitate the ideal of user empowerment. user freedom of choice, so that our choices as speakers and as receivers of information would not be subject to the centralized control of these dominant, powerful gatekeepers. And one of the ways to do that is through antitrust regulation, to really put some muscle into those laws so that there could be alternative platforms that would emerge that would give different options to us users, including exposure to a wider range of ideas. I think that was one of the goals that Elon Musk announced that he had for X when he took it over. I'm not sure to what extent he's actually adhered to that. I haven't followed the details. Another very important approach is interoperability. Now, here, I'm not an expert on these technological issues, so I'm just quoting what I read on EFF's excellent website. And that is that these platforms should be available for other software from other companies that users could choose to coincide with our own preferences about what we do want to see and what we don't want to see. So those are some promising alternatives. I don't know how realistic it is that they would actually be enacted. There seems to be much stronger lobbying in favor of speech restrictions online, and I think there's kind of a collective action problem here for any kind of communication that is seen as being dangerous, and disinformation now is something that everybody just assumes is really, really dangerous. There isn't as concerted a general free speech lobby that's opposing that. I've tried to drum it up. Others, ACLU and EFF have tried to drum it up, but I think we haven't. So maybe there's low-hanging fruit here, Jay. Maybe we could help marshal, really strong lobbying and advocacy efforts, not only in Congress to enact antitrust or interoperability requirements, but also to advocate to these companies. After all, they are responsive to their consumers, to their customers. And if those of us who cared about free speech and opposed the content moderation policies that they're enforcing raised our voices, we might have an impact.
I mean, I think it's. Oh, sorry, Monica.
Oh, no, go ahead, Jay. Go ahead.
Yeah, I think that's the idea that the companies themselves, if they competed, would have policies that would attract people and allow them to people to choose the rules they wanted. I think that's actually quite an attractive idea, right? So like there's a alternative that popped up to Twitter, or I guess X, after Musk bought it, called Blue Sky, at which a bunch of scientists jumped off of Twitter and moved to, and I have to say, I'm like I've looked at it, and it's just it feels like it's a bland, quite bland. Like it's not the fight in Twitter. Like Twitter's a fight. It's really kind of a fun fight, actually. Once I had my account blacklist lifted, so it's and I personally prefer it, and it's but I think having that alternative is actually quite healthy. Like if someone doesn't want that fight and they want to go talk to other people, they can go do that and see what the market says. In 2020, it was really kind of disheartening because there were some other platforms that were popping up. And Parler, yeah, and it seemed like there was this concerted effort by Apple and others to basically destroy it. I mean, that's such a clear. I mean, like if it was the government pushing it, that was bad. If you had a whole bunch of companies using its market muscle to destroy it, that's also bad. So I think something like an antitrust, I think, does seem quite promising. Whether it's but I don't know. I have to say, after we lost the preliminary the Supreme Court ruling on the preliminary injunction, I've been quite depressed about it. I mean, I just didn't.
Well, please don't be depressed. I'm an activist, so you're a recent activist. I'm a lifelong activist, and the more you do it, right, Monica, the more optimistic you become. them. One of the taglines I
Wow.
quote under my email signature, nobody reads down that far, but I'm actually quoting somebody else who says that optimism is even more the result of activism than its cause. And that's fair, because I do see over the course of a fairly long career now that for all of the disappointments, and this ruling was certainly a disappointment, the overall pattern, even from the quite recent past, is very positive. The idea, the whole theory that was raised in your lawsuit, Jay, is a very recent theory. It was only put forward a couple of years ago. Before that, people were kind of flailing around saying, well, we should hold the social media platforms culpable for suppressing expression on this so-called public function theory, which was a more well-known doctrine that if they were performing a function that traditionally had been performed only by the government, such as providing a communications platform, that would be a basis for enforcing the First Amendment. I don't want to get too wonky, but the point is that this idea of coercion really wasn't even put forward until just a couple of years ago. So the fact that it got so far, and your case was one of the very first to embody that theory that was then advanced only in law review articles, basically, in an actual litigation. The fact that it was accepted by the lower court, that it was affirmed by the intermediate appellate court, that it garnered a very powerful, I think, dissent by Alito. That's really, in a fairly recent historic perspective, quite a stride forward. And the Supreme Court has given a blueprint for the kinds of evidence and factual connections that could be shown. I mean, it didn't say you will never be able to establish standing in this kind of case. To be sure, it made it challenging, but not impossible. So I choose to see the glass at least half full, if not more so.
Nadine, I appreciate that, because I do. I mean, the question is like, what should I be doing as a non-lawyer to try to advocate? Because I do think that this is such a fundamental thing for science, that this kind of speech. And Monica, I so appreciate the activities of FAIR to like highlight in medicine exactly these issues. It's I think absolutely vital for our progress in science and medicine. It's just to have these speech rights. So I'm going to keep advocating for them. I'm not going to give up. But I do think I don't know. I guess you're right. I'm a recent
Let me tell you, Jay, because this case, along with just about everything, it seems, in our very polarized political climate, people tend to look at it through the political valence that I keep coming back to, that they see this, oh, Biden won, that's good, we're pro-Biden, or, we really like the public health officials who were saying things that you disagreed with, and so that's okay. But so I find that it's really, really helpful if you can give examples that would appeal to people on the left end of the spectrum of other public health policies where they might be very nervous if another administration comes in and starts suppressing it. One of my very best friends happens to be an OBGYN in San Francisco. And when I sent her the link to this program, she responded by saying, she didn't look at the details of exactly, she just looked at the title, which was, something about to what extent can doctors be suppressed. And since she's an OBGYN, she said, oh yeah, you wouldn't believe the restrictions on information about abortion that are being imposed now. And I would not be at all surprised if a future Trump administration, or certainly a present DeSantis or other, conservative Republican anti-abortion administrations would use this power to try to suppress information about abortion or contraception, other policies that are favored by the political left. The very same underlying principles are at stake, right?
Yeah, no, I think that's a really good point, Nadine. I think it's, I mean, I've never viewed this as partisan. I didn't view the Great Barrington Declaration as partisan. It's just the Swedish public health authorities that adopted policies very similar to that, where it was a socialist Swedish government that adopted it. And it was a right-wing government in the UK that adopted the lockdowns. That Sunetra Gupta, who wrote the Great Barrington Declaration, is an ardent labor supporter on the left in the UK. So I never viewed this as a particularly right wing or left. It's just a question of public health, and then it's a question of speech, and it affects all of us, whatever our political leanings. Right? Everyone. This is what I think is part of the genius of America, is that no matter what your political ideas, you can say them, and we can have a conversation about them. No matter what your scientific ideas, we're not going to ever have a Galileo situation.
Mhm.
I
You
guess.
know, one of the, and I think perhaps even from your congressional district, one of the members of Congress who has been great on these issues is Ro Khanna.
Oh,
Uh,
he has been wonderful. Yeah.
and very unusual because he's a member of the Progressive Caucus in Congress. And sadly, when you say you don't see these as partisan issues, I hate to break it to you, maybe it has become evident that free speech has become associated with conservative, if not even far right positions recently. And so it's very refreshing to have a prominent progressive such as Ro Khanna be really excellent, including on online speech in general and on this particular issue. He was one of the few, perhaps the only Democrat to speak out against the kinds of government pressure that we're talking about in this case.
So I wanted to maybe in the last 10 minutes, see if we can get to a few questions. Okay. So from one of our viewers, is there also a freedom to associate issue? For example, if I use X or Facebook to connect with people like Jay and others who share his ideas, but he is blacklisted and or suppressed, is my freedom to associate implicated in addition to Jay's freedom of speech?
I would
Very
say
good question.
the answer to that is yes, but unfortunately, it's not going to change the constitutional analysis, which would be exactly the same, that there would be allegedly no standing to assert that particular First Amendment claim any more than the free speech First Amendment claim.
Let me just answer that with a public health
Okay.
point. So there was this explicit demand that from the federal government, from the White House to Facebook, to disband vaccine injury groups. So people who were legitimately vaccine injured wouldn't be able to share information with each other. And this is like a lot of like patient advocacy groups and patient groups, they form up. And this was actually the weird thing was that these were like private groups. They weren't even like publicly available to everybody. Just people who were vaccine injured would sign up for them. That kind of association is actually really important for patient healing, actually, and for because you have something that's happened to you. You want to share information with others who have had it happen to you, and so it's again one of these things where like speech is good for health, association is good for health. These are all like you would think of them as in an abstract way, but they're not abstract. They're real and tangible things.
Great point.
This is a long question, but I think it's kind of interesting. If my understanding is correct, the Supreme Court decision on Murphy only answered the question if a preliminary injunction is warranted. Okay. If so, it sounds like there's a lot more that is needed to fully litigate the case on the merits with our friends at NCLA. If anything, perhaps, and this is what I was thinking, the Alex Berenson case against X, which I'm sure you know, or Twitter, is a much better case to bring to the Supreme Court. I've learned from Four Boxes Diner, this is a person, Mark W. Smith, that this Supreme Court makeup does not like taking cases on an interlocutory basis. So, interesting question.
That's really wonky, and
It's very wonky.
it is.
Someone's really digging deep.
It is true, as I indicated earlier, that this is not the death knell even to this for these particular plaintiffs, let alone to others. And I think I saw a statement, but you probably know this better, Jay, but I saw a statement from the lawyer, Janine Yanis, for the NCLA, the New Civil Liberties Alliance, who litigated the case, that they were going to pursue the claims. Is that
So
correct?
it is. So this was on the preliminary injunction, which if I understand right, is a generally a higher standard to establish than the case itself. The case, which you already have a lot of discovery, is going to go back down to the lower court, and we're asking for more discovery so that we can meet the burden, I guess, Supreme Court set. I mean, I hope we prevail on it, and I hope Alex Berenson prevails on his case. What I worry is that if we have to meet the standing requirements that are set by the Supreme Court, and let's say we meet it, let's say Alex meets it, let's say RFK Jr. or someone else meets it, that still doesn't solve the problem that the government then essentially seems to be able to have the right to suppress ideas that don't have a entity that can meet the standing requirement.
Well, one of the good things about the standing doctrine is that as long as there is even one plaintiff that has standing, the court has to rule on the merits on all of the issues. So one would be enough to solve that problem.
Interesting. So then that would mean that they would rule on the merits and say the government doesn't have the right to like suppress ideas. Well, that's okay. Now I have some hope.
And I on that proposition, let me assure you, I'm going to give you another basis for optimism, Jay. As a matter of First Amendment principle, this court would agree 9-0 that government may not suppress ideas. That statement from decades ago that there is no such thing as a false idea under the First Amendment. I don't know a single justice who would disagree with that. The debate here is over whether there was, in fact, suppression as opposed to encouragement or discouragement.
Interesting.
I'd just like to end with one question. It's a little long, but Jay, if you bear with me, I think we know that your case, if it's ever decided on the merits, hopefully soon, it has implications far beyond medicine, implications for free speech in so many different areas. But I want to talk about the landscape for you and your colleagues going forward. So as you said earlier, we've now learned that we made many mistakes, during the pandemic, especially, as you also mentioned, the cascading harms from lockdowns, the cost to children's psychological, social, and academic development. But public health officials like Francis Collins are also assuring us now that having another pandemic it's not a matter of when, it's if. So considering that much of the misinformation in the last pandemic turned out to be accurate information, do you think clinicians and other doctors like your colleagues, have learned from these mistakes such that misinformation won't be as much of an issue in the next pandemic? In other words, do you think going forwards, doctors, scientists, experts will be more willing and open to other opinions and perspectives so there won't be a need for the government to step in and censor dissenting voice? Does that make sense to you?
Yeah. So, I mean, I don't know that we've learned that lesson.
Really?
As a medical profession. I mean, I think what's happened. I mean, just recently there was a colleague of mine, a very prominent one at Stanford, wrote a piece in the New England Journal arguing that that Stanford and other high universities should take official positions on like public health matters during the pandemic, and citing the example of what happened at Stanford in 2020 as a reason for why it should do this. And I think that a lot of the folks who had sort of controlled the levers of power during the pandemic on the medical side, they haven't really come around to the idea that they really did a lot wrong. And so their view in the medical literature, like the top journals view, the main problem was that there were people outside of their power base that were saying things that contradicted them and confused the public. And they point to examples that actually legitimately were like some people were saying things about the vaccines, the magnetizing or whatever, like some nonsense that were not correct. The issue is that, like, to me, is like one of trust. I don't see that the public has regained trust in the medical profession. I don't see how it will until what you said happens, Monica, until there is until the medical profession comes back to the idea that we have to talk to each other, even especially when there's not a new situation where we need everyone's minds together thinking about things, even if they sometimes arrive on wrong ideas. I don't know. This is something I'm worried very deeply about, and I think the next time there's a pandemic, the same thing will happen again. The inclinations are still there, and the lessons have not really been learned. The COVID inquiries that have been done in places like the UK have not included the dissident voices. So I don't know. I'm sorry to be such a downer, but I do think I'm going to keep fighting on this. But I do think that's something I'm deeply worried about, because there will be another pandemic. And I do think that the speech restrictions that happen, mainly I think because people were so scared, even within medicine, will happen again.
Well, some sage said all great truths began as blasphemies. And thank goodness we have scientists and others like you, Jay, who have the courage of their convictions and principles, and are willing to pay what I'm sure is a great personal price, and to some extent professional price, for standing up for those truths. That's really wonderful. And I know that's going to continue. So that's what gives me optimism.
I mean, I do think that there'll be a lot more people that will speak up this time, not just among medical professionals, but just regular people. It'll be harder, but until like because it's in the back of my head, I have this idea that people aren't themselves when they're scared. And so the question is, how do you structure society so that it does the right thing when everybody is scared? Like military has these, like, the kind of procedures of disciplining people so that the soldiers, so they do the right thing even when they're scared. The pilots have checklists, surgeons have checklists, but public health doesn't seem to have that kind of sort of immune system built up so that it does the right thing when it's scared. And that's the thing I've been thinking about.
I like that metaphor, the immune system against overreaction.
Well, thank you so much, both of you, Jay and Nadine, for joining us this evening and breaking down these very complicated concepts. I'm sure everyone will agree you've given us so much to think about, and I think you've answered a lot of important questions that have been on our minds. As a final note, I have to do a plug here. I would like to remind all of you that FAIR operates entirely on donations, and we do this through generous gifts from people like you. So if you appreciate the work FAIR is doing, we would invite you to consider making a donation. Your gift allows us to continue doing this very important work and having such wonderful and insightful guests on our webinars. Anyway, you can find a link to our donation page in the chat. And once again, thank you all for joining us this evening. We look forward to seeing you at the next FAIR and Med webinar on informed consent. There will be many, so stay tuned. Take care and good night.